If you're on a Georgia HOA or Condo Association board, you've probably gotten no less than 4 emails from your association's attorney about this new law that's come out. And probably all of them said that they're sweeping changes, and you're likely still a little confused about what the law actually means for your community. So let's fix that. Because most of Act 715 doesn't hit until January of 2027, but one piece of it already hit. It took effect on July 1st of 2026. And if your board sends a collection letter this month the old way, you can lose the right to recover your attorney fees on it. So that's what we're looking at today. Georgia HOA and Condo Law Act 715. That's a mouthful, I know. One section of it is live now, like I just said, and everything else you've got until January to prepare for. And so this video will give you the details of what you need to do. Also, this is an update to a previous video that I made earlier this year about the bill before it was signed into law, and I'll leave a link to that in the description just in case you want to go into a little more detail about it. I think it's a slightly longer video, some more detail. I'm Joe Braun. I'm the founder of Solume, an all-in-one HOA and condo management system built to help boards organize their communities, document their decisions, and stay ahead of changing compliance requirements. And if you're serving on a board and still trying to understand what the heck you signed up for, subscribe to this channel. We create videos like this to help board members understand the law, finances, and the responsibilities that come with running an association. All right, let's start with what this thing really is. Governor Kemp signed what was known as Senate Bill 406 into law on May 12th of 2026. It's called the Georgia Property Owners Bill of Rights, and it's now on the books as Act 715. So if you hear me refer to something as Senate Bill 406 or Act 715, they're essentially interchangeable. It passed the Senate 51 to nothing. Did you get that? 51 to nothing. I want you to sit with that number for a second because it tells you something that probably the news coverage just kind of glossed over. This was not a fight. Nobody in the Georgia Senate stood up and said, our HOAs are fine, right? Leave them alone. They're doing great. Not one. This was bipartisan. That's how much support it had. The law does 4 big things. So we're going to break these down. 4 big things. Number 1, it creates a mandatory registration system with the Secretary of State. Number 2, it gives homeowners a formal complaint process that the state will actually hear, or supposedly hear. Number 3, collections. It changes what boards can charge and when they can foreclose. And number 4, it makes you keep your HOA or condo association records for 10 years. 10 years. We're going to go into these a little bit more detail in just a minute. Almost all of that starts in January of 2027. Almost all of it. Not all of it, but almost. The part that already took effect in July falls under that 3rd category of collections. It changes what an association must do before it can recover attorney fees from a homeowner. That part of the law took effect on July 1st, and it applies to any action filed on or after that date. If your association is subject to the POA Act, you are now required to follow that portion of the act. Here's what that portion of the law actually does. Before your association can recover attorney fees from a delinquent owner, 3 things now have to happen. Number 1, you have to give the owner a detailed itemization of the fees, not a number at the bottom of a letter that just says sum total $5,400, an itemization. Number 2, you have to give them 30 days to cure, right? 30 days to fix the problem before you proceed. Number 3, a judge gets to look at those attorney fees or all those fees and decide whether they're reasonable before they're awarded to the association. And 2 more that are sort of buried in that same section. Number 1 is your association can no longer refuse to accept a payment from an owner on an assessment. And you cannot assess or collect accelerated assessments. That's where you kind of, a single missed assessment payment lets you demand the whole year at once. You can't do that anymore. I know it sounds kind of shady, but people were doing it. Now, I want to be honest about something because I think this is the real reason the law passed 51 to nothing. A lot of boards, I don't think, ever intended on being that aggressive. They just handed their collections to an attorney and the attorney ran a process, right? And the fees stacked up and nobody on the board ever saw an itemization either. The board, they weren't being cruel about things. The boards, they just weren't looking at the bills either. That's over. And practically speaking, your first move this week is a phone call to your association with one question. Does our current demand letter satisfy Section 7 of this bill? Just ask them that. If the answer is anything other than a fast yes, stop sending them until it is. Have the letter rewritten. So that's currently in effect now. So what's on the calendar for January? 4 things. And you should start preparing for these now. Don't wait until later in the year, but just because they take effect in January doesn't mean you shouldn't start working on them now. Number 1, register with the Secretary of State. If you don't, you become a non-registered association. And you can still collect regular assessments and special assessments, but you cannot assess or collect fines or fees. You can't impose accelerated assessments. You can't file liens or initiate foreclosure proceedings. You're really not even given a warning about this. You just lose the power entirely. Number 2, keep every financial record for 10 years. 10 years. Assessments, special assessments, fines from violations, fees, liens, foreclosures, everything. And it's best to keep it digitally in the cloud so that it's not lost from one board member to another. Don't trust that it's written down somewhere, okay? And I'm going to come back to this in a little bit because there's a lot of implications to that. Number 3, for POA Act associations, the foreclosure floor or minimum goes from $2,000 up to $4,000 and only unpaid assessments count towards it. Fines and fees no longer do. The new limit is either $4,000 or 1 year of regular assessments, whichever is lower. In other words, an association cannot begin to foreclose unless the homeowner owes at least $4,000 in assessments alone, regardless of how much they may owe in fines or late fees or attorney fees or other charges, okay? I know this is a little confusing and I don't want to lose you with a bunch of math calculations or scenarios, so I'm just going to move on. And if you have any questions, you can reach out to your attorney. I'm sure they'll be happy to clarify for you. Number 4, when an owner makes a payment, the association must apply it to the assessments first. Regular assessments come first, followed by special assessments, and then specific assessments. I know there's a lot of variability within there, or like definitions of things. Only after those are current can the payments be applied to other fees and fines. That means an association can no longer apply a homeowner's payment to fines or fees while leaving the assessment's balance unpaid. You can't do that anymore. That last one actually matters more than it sounds, and here's why. A lot of governing documents have the old $2,000 number written into it, and a lot of them let fines count. They kind of aggregate that dollar amount together. Those documents are going to conflict with the law, which means somebody has to actually pay attention to your CC&Rs before January. Look into them. You have to get them updated if they're not. And that somebody is likely you. Again, I'm sure you're going to pass this on to the attorney, but it still rolls up to your responsibility as the board member. That is part of the job now. All right, so what do you do this week? What can you actively put into motion? There's 2 things. Number 1, call your attorney about your demand letter. We talked about that earlier. And then number 2, put Act 715 readiness on the next board meeting agenda. Not in December. January is far too late. Put it on the agenda for your next meeting. And if your records live in a binder in someone's garage or in someone's Google folder or a Word document, the 10-year retention rule is going to be the hardest part of this law for you, not the easiest. Getting your association's documentation and financial history into one place where you can actually produce it is exactly what Solume does. Solume helps Georgia HOAs prepare for these new requirements by keeping assessments and fines and fees and liens and foreclosure records organized in one system, preserving a clear payment history and creating an audit trail that shows how homeowners' payments were applied. It also helps boards track compliance deadlines, maintain governing documents, and keep the records they may need to produce if a homeowner files a complaint or the association's actions are challenged. We help with all of that. Listen, I know we'd all like to think that your property manager has everything under control, but the reality is that not everybody is as concerned with record keeping as they should be. This has to be a high priority within your community. So even if you're under management, it is strongly recommended that you have a system like Solume in place for internal record keeping. Again, just because a lot of communities will rotate through their property management company or property managers over the course of 1 or 3 or 5 years. So you need to have an internal system that keeps track of everything, regardless of who's coming in and out on the board or on the management team. Georgia's new law raises the standard for how associations document their decisions. If your board needs a better way to organize its records, track payments, document decisions, and prepare for these new requirements, take a look at Solume at solume.com. One more thing, and you need to hear this. I am not an attorney, right? I run a software company. This video is a practical summary of the new law, not legal advice, and how the law applies to your association may depend on your specific situation. So take these questions to your association's attorney and make them earn that retainer that you keep them on. Thanks for watching. I'll see you in the next video.